Post-sentencing considerations. We should be bing, bing, bing again, because there's a lot to talk about here as well. So, security considerations after you sentenced obviously depends on the risk and the severity of the crime and your likelihood of rehabilitation. So, if you're someone that gave police information on another offender so that you could reduce your sentence, you will have security considerations, okay? Do you need more protection? Do you need to be placed in a certain area of the prison? That kind of stuff for your safety. Protective custody. This is a type of security consideration. It's a separate area of the prison. It's a type of segregation from other offenders for the protection of offenders who are vulnerable to attack. And correctional authorities have a duty of care for the offenders. So type of prisoners who are vulnerable to attack would be police officers. The people I was just talking about, people who have given information on other offenders to reduce their sentence, and people with particularly violent crimes, especially crimes against women or children. It restricts opportunities for those in custody to work and access education programs, because obviously to be able to work and be involved in the education programs offered to offenders, you need to be able to work together and work with other offenders, which isn't the case here. Parole. Okay, this is the big one, parole. Parole, as I said, is a conditional release of a prisoner from custody after the completion of their minimum non-parole period. So with Loveridge, he had a 10-year sentence, 8 years non-parole. If he was fine and he didn't attack anyone and wasn't violent in those 8 years, after 8 years, he can be released on parole. The aim is to reintegrate them into the community smoothly and ensure they will not reoffend and reduce recidivism, okay? So, to try and reintegrate them slowly back into the community. There's likely conditions, right, because it's a conditional release. So let's say Loveridge won't be able to leave his house. He won't be able to not check in with the correctional officer. He has to check in with the correctional officer. All that it still incapacitates him in a way, but it's still also helping him reintegrate back into the community because he's outside of prison. It encourages prisoners to behave whilst in prison and undertake rehabilitative activities. If you're released on parole, you're known as a parolee. Parolee is under direct supervision of a parole officer because you're technically still serving jail time. Now, the big issue with parole is that people who are parolees, amongst parolees, we see high rates of recidivism. Okay, so on one hand, the aim of it is to reduce recidivism by reintegrating them back into community and getting them adjusted to society again. But in practice, there are high rates of recidivism. We see them reoffending really quickly. A lot of them breach their conditions of release, okay? If I wanted to talk about that in an essay, I would definitely jot it down. Jill Mega is a great case, okay? Well, it's a sad case, but great to use in legal studies. Bailey, R vs. Bailey 2014, I believe it is, 2014. He was on parole for being a serial sex offender when he murdered Jill Mega. Okay, so that's again, not a great case, very sad case, but a good case to look at in legal studies. Preventative detention, another one that's great to look at, okay? Preventative detention. So there's two types of preventative detention, but both are controversial. So preventative detention is where we imprison someone, incapacitate them before they've committed a crime. So let's look at the two different types. So there's Terrorism Police Powers Act of 2016, New South Wales, which allows allows the police to detain and question suspects up to 14 days without charge, okay? We can hold them or incapacitate them for 14 days without a charge. The issue is that it infringes the rights of individuals. Even more so, the big principle here, because remember, in legal studies, in our essays, we like to bring it back to our legal principles, okay? The principle of being innocent until proven guilty. Okay, the presumption of innocence. That's the key phrase we're looking at. The presumption of innocence, again, has been obliterated here. We're not even taking that into account. You are literally innocent until proven guilty. You have that presumption of innocence. Not only have they not been proven guilty, they haven't had a trial, they haven't been sentenced, they haven't even committed the crime yet. Okay, so it's considered a massive infringement of human rights, okay, which sets us up nicely for human rights. But the reason why this is such a good body paragraph in a crime essay is because on the other side of that, because of the nature of the crime, terrorism, society is fine with it. Because it's almost like, yeah, we could be possibly infringing on their human rights because they could not, be committing a crime and they could be completely innocent. It's not worth the risk, though. It's not worth, 10 people dying, 100 people dying, whoever dies, because of this one life that we are infringing on the human rights. It is up to you what your stance on that is, okay? I don't want to sway you, but that's the issue here, okay? Nonetheless, things you need to talk about are all of those perspectives and the presumption of innocence. I don't want to go on a tangent, but one thing I want to just quickly say, and I think I'll talk about it again when we get to essay writing, but I always get questions. I think there's a question that said something about how to write a Band 6 essay. Band 6 essays are the ones that consider all perspectives involved. Victim, offender, society, okay? In every single body paragraph. You shouldn't have one body paragraph on preventative detention and how this is bad for the offender. You should have one body paragraph on preventative detention and how this is bad for the offender, but good for potential victims and great for society. Okay? That's that complexity. That is what is characteristic of a Band 6 essay, considering every single perspective and backing each perspective up with evidence. All right? Hands down, that is what is the biggest thing that Band 6 students do. We'll return to this now. Also that applies for all your essays and your electives too. Like if you're doing family law, both of the parents and the child as well. Okay, if you're doing consumer law, the business, the government, and consumers. If you're doing world order, the different governments and their citizens. Okay. Every perspective, no matter what essay you do in legal studies. Okay, sorry, I know that was off topic, but I think that's really important. Okay, where were we? Yes, that's the issue of preventative detention. Continued detention, similar, but at least here we've proven that they've committed a crime. So continued detention is after you finish serving your sentence, you're kept in prison for an extended period of time because you're considered to be high risk. Okay, the issue here is it's not so much presumption of innocence because we've already convicted them, so they've been found guilty, so we know they've committed the crime. The issue is it's still a human rights issue because they've served their time. And then you start to think, okay, well, where's the limit? They got told they were going to serve, 10 years in prison. Where's the limit? Where does it stop? At what year do they actually get to be released? Okay. However, just like with preventative detention, it's protecting the community and it's protecting potential victims. So again, I'm not going to tell you what to think about that, but it's important that you have a judgment on that. Do you think it's worth it? Or do you think, no, that's actually unfair for these offenders, we should be releasing them? The power to do this exists under the Crime Serious Sex Offenders Act 2006, New South Wales, because typically it's for sex offenders who we believe are high risk to reoffend again. So a good example, if I was doing a body paragraph on this, again, hint, hint, nudge, nudge, yes, this would be a great body paragraph. Kenneth Tillman was the first person to be detained after the expiration of his 10-year sentence for sexual assault. Okay, I'm just going to have a quick sip. Okay, and that's an example of a case you could talk about. The Attorney General can apply to a court for continued detention if the offender is satisfied to a degree of probability, if the Attorney General is satisfied to a degree of probability that the offender is likely to commit another offense. Sorry, I must have been really tired while writing that. Yes, basically, the Attorney General can basically continue the detention if we believe they're going to reoffend. The allowable purposes of the continued detention are to ensure the safety and protection of the community, to facilitate the rehabilitation of serious sex offenders. Yes. All right. Crimes, High Risk Offenders Act 2013, New South Wales. This is also for continued detention. This is for non-sex offenders, but just general high-risk offenders. A great one by a great case to talk about here is Rebecca Butterfield, where her judge said that she's too violent to ever be let out again in society. Okay, because we believe they're going to reoffend. Again, it protects the safety of the community and victims. However, there are major justice issues. The individual has served their sentence. Law Society, okay, which is a almost like the chief law or barrister group in Australia, has deemed it unfair and unethical, and it's seen as re-punishing offenders for the same offence denies civil liberties. So you re-punish them over and over when they've already served their time, okay, which is a human rights issue. Okay, sex offenders registration. This is another thing you could talk about in an essay for crime. If you've committed any sexual offences against a child, you'll be registered as a sex offender for 8 years. If you're a young offender when you commit the crime, you'll be registered for 4 years. Now, the whole point of this is not only to name and shame, but also keep the public aware of dangerous sex offenders. Okay, police and also employers and medical staff, if need be, anyone that might be endangered by a sexual offender. Police must be informed of the address, any address change, a change of name, holidays that this person's going on, in an attempt to protect the community. It monitors the offenders so reoffending is minimized. Okay, there's continual monitoring of the offender. There's a push to remove sexters from this, specifically young offenders. So we know that this is a big issue with young people sending illicit photos and messages to each other. Currently, if you're found to be doing that, you'll be registered on the sex offenders list. There's a push to remove them from the list, though, and this is something you could talk about because this is a highly contentious issue, and this is something that's new, which is something we love in legal studies. It's a new contentious issue. Jeez. The reason why we want to kind of get it removed is because it's not kind of seen as predatory, because oftentimes the teenagers or the young adults are the same age, and a lot of the time it mostly comes down to stupidity, honestly. It's not really predatory as like there's a massive age gap or something like that most of the time. If there is a major age gap, that's not what the push is about. The push is about young teenagers, young adults of the same age sending illicit photos, videos, texts to each other. And that's definitely something you could talk about. Okay, next thing, deportation. So, deportation is the forcible removal of a person from a country and returning to a person to their country of origin. So, if someone commits a crime here, they can either serve their sentence here, and let's say they're from Chile, we send them back to Chile after they've served their sentence, or they've committed the crime and we send them immediately back to Chile. This exists under the Migration Amendment Character and General Visa Cancellation Act 2014. Anyone who has served a jail sentence of 12 months or more in Australia can be deported. Deportations are automatic. We have some exemptions and the opportunity for the minister to intervene, specifically if this person has a family here and a life and, is really integrated and assimilated into the Australian community. They can apply to the minister to not deport them because they're automatic. The change had resulted in a 500% increase in the number of criminals deported. Again, this is highly contentious. Do you agree with deportation? Do you disagree? This is something you could talk about in an essay. And there are many cases you can find of a lot of it seems to be happening to a lot of men. I'm not sure if that's because men commit more crime or if it's, I have no idea. But nonetheless, you can find many cases of men kind of appealing to the minister to cancel the deportation because they have their whole family in Australia and they want to stay in Australia and there's no point going back to their home country. And there are some that have been successful, some that have not been successful, and actually a lot that have not been successful. That's up to you. Whether or not you think that's fair or not, that's up to you.